that for correctional supervision?
That is correct. It is so, my lord.
In other words, that would determine or entail a determination whether somebody would look after her, she's got a house to stay, and that she's got a fixed address, so that people can go and check up on her if required to do so.
That is correct, my lord.
So you will not call to establish whether correctional supervision is in fact an appropriate sentence in this case.
My lord, I do not have a mandate to prescribe to the court. I said, my lord, I do not have a mandate to prescribe to the court on which sentence to impose. It's just, it is, I leave that entirely up to the court. The court will use its discretion to impose such sentence. But however, should the court wishes to impose such sentences, because the accused has got a fixed address, she become a candidate to such sentence. However, it's entirely up to the court to decide.
Can I refer you to your report on page 4? Just above paragraph B, the family system. The last sentence, just above that, the following is mentioned: the Department of Correctional Services also provides psychological and spiritual services should a need arise.
That is correct, my lord.
Can you maybe expound on the specific facilities that are available in respect of psychological services at the correctional services?
My lord, as far as we are concerned, inside the prison, it is available. We have centers inside the prison. There are social workers inside the prison, as well as psychologists inside the prison as well. Even though they are available at the community corrections, and again inside the prison, we have such services.
And during your interview with the accused, did she at any stage give an indication that she would require any psychological services?
My lord, as I've said in my report, during the interview, she appeared to be, she was physically okay, and I could not determine anything. The only thing that she was emotional. She was just emotional.
If the accused needs to be incarcerated, do you have any knowledge as to where, at what specific facility will she be incarcerated?
My lord, in Joburg we have Johannesburg Female Prison. I assume she will be accommodated in Johannesburg Female Center, Correctional Center.
And these psychological services, is that available at that specific place?
They are available. If there's a need for that, they are available, my lord.
Thank you, my lord. That's not the
Okay, I understand, ma. Thanks, my lord.
Right, next witness.
Mr. Hay, Hay. Zain Khan. I'm not surprised we don't have a police officer in this court. Zain Khan officer.
State your full names and surname on the record.
Zain Kai, hello.
Do you have any objection in taking the oath?
No,
Do you swear that the evidence you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Raise your right hand, say so help me God.
So help me God.
So your names are Zain.
Zain.
Z-A-N-E.
Z-A-I-N.
Z-A-I-N. And the surname?
Halle. H-A-L-L-E.
H-A-L-L-E.
E.
What is your professional calling, sir?
I'm a criminologist.
And what are your qualifications?
I have an undergraduate degree in psychology, majoring in psychology and criminology. I also have an honours degree in psychology, an honours degree in criminology, and I'm currently completing my master's degree in criminology.
So in criminology, you have an undergraduate degree and an honours degree.
Yes, that's correct.
And are you in private practice or in state employee?
Private practice. Private practice.
And you have been requested to compile a pre-sentencing report with regards to the accused Ms. Manqele before court, is that correct?
That's correct.
So you've been approached by whom?
Vilakazi and Buthelezi, attorneys, my lord.
Attorneys for the accused.
That's correct.
You confirm that your report that you prepared for the court also consists of a synopsis of your safety forming part of the report. Is that correct?
That's correct.
I have a signed copy that I beg leave to provisionally hand to the court so as to enable the witness to read it into record. And after which I will formally request it to be accepted as Exhibit N. I also confirm, my lord, that I have made same available to my learned colleague for the state. As it may please the court, my lord. You can proceed to read the report into record, and I might indicate to you that if for any reason you wish to do so sitting down, please bring it to the Honorable Court attention, and the court will evaluate to allow it to proceed.
Thank you very much. Starting off on the criminological details on page 2. As the assessor, I have a BA Psychology, Honours BA Psychology and Honours BA Criminology at the University of South Africa. I'm currently completing a Master's of Arts in Criminology through UNISA. I was instructed by Buthelezi Vilakazi attorneys to compile a pre-sentence report for Ms. Manqele. Career experience, I have worked for Kalisa Social Solutions, which is a non-governmental organisation, since completing my undergraduate, majoring in psychology and criminology in 2007. My duties have included extensively working with communities, children living and working on the streets, maximum violent offenders at Zonabata Correctional Facility, Leeuwkop Correctional Centre and Kosi Mampura Correctional Centre. I've been trained in and have facilitated numerous programs, including but not limited to restorative justice, victim offender mediation, cognitive behavioural modification programs, narrative behavioural modification programs, as well as young sex offenders behavioural modification programs. My main focus has been to facilitate violent behaviour programs, specifically with youth and maximum offenders within correctional centres as well as places of safety. Through diversion, I've also worked with children in conflict with the law and have written numerous court reports. I sit on the steering committee for both the Prison Overcrowding Forum, which was run by the Department of Justice, led by High Court Judge Bertelsmann, as well as the steering committee for child justice under the new Child Justice Act. The purpose of the report: pre-sentence reports are deemed necessary in order to gain an in-depth understanding of the accused before the court. Sentencing of offenders requires careful consideration of all aspects of the offender's life. While the criminal procedure during the trial is usually a ceremonial, in-depth and methodological process, the decision about the future of the accused once they have been found guilty is usually a speedy and unceremonious one. There is an acute need for pre-sentence reports, as stated by Judge Irvin Kaufman, to ensure that the correct sentence is handed down that will benefit society, victim and offender. From Tablanche. When someone studies law in South Africa, they concentrate purely on laws pertaining to the criminal acts, and they have no subjects in the field of humanities, which unfortunately leads to little understanding of psychological or criminological factors relating to the offender's passage to crime, an understanding of how vastly different each offender's path to crime is. There may be general risk factors, such as lack of parental supervision and substance abuse amongst many offenders, but the reasons pertaining to the substance abuse could differ greatly for each offender. The judicial officer, who only knows of the criminal procedure before them, cannot possibly know what the right sentence is for the stranger in front of them, without a clear insight into the person's life history. From Hoffman and Zeffert from Terre Blanche, the opinion of the expert witness is admissible whenever by reason of their specialized knowledge and skill they are better qualified to draw inferences than the judicial officer. In terms of this, Tablanche states, the main purpose of a pre-sentence report is to provide guidance to the exercise of discretion, to assist the presiding officer in gaining a better understanding of the offender and their crime. This is one of the triad of factors the court has to consider when constructing sentence. Assistance by experts in the field of human behavior can therefore be of much assistance in determining the effect this factor should have on an individual sentence. Care should be taken to understand future risks, crimogenic, which are crime-causing factors, that have a bearing on the case in front of the court, and any further relevant issues that become known to the report compiler. Media can have a detrimental impact. Emotive cases create public pressure, and judicial officers are often under the spotlight to appease society. It is crucial that judgments are done in a professional manner with as much knowledge of the accused as possible to ensure unbiased sentencing takes place. In terms of the interviews were completed with the accused attorney, as well as a friend of the accused. An interview with the investigating officer also took place, as well as a telephonic interview with the prosecutor. The total time spent interviewing compiling this report is in excess of 23 hours. The interviews with the accused took place on Friday the 26th of February 2016 at her place of residence. The interview started at 9:35 and was completed at 11:40 a.m. The second interview with the offender took place on Friday the 4th of March 2016. Interviews with Ms. Vilakazi took place on the 24th of February 2016. The interview started at 12:35 and completed at 13:20. The interview with Mr. Malaka was conducted on Friday the 26th of February at his offices in Alexandra. The interview started at 13:10 and ended at 13:30. Ms. Nawa, a lifelong friend of the accused for verification, was interviewed at her place of employment in Sandton on the 26th of February. The interview started at 15:45 and ended at 16:40. In terms of definitions, a criminologist is a professional person who has completed at least their BA honours in criminology from a recognised university. Crime can be defined as an intentional act in violation of the criminal law in a country which has been committed by an individual knowingly. From Teblanche, a pre-sentence report, Section 274 of the Criminal Procedures Act, states that a court can, before sentencing an individual accused of committing a crime, receive information which is used as evidence in order to pass a proper sentence. The accused can give evidence through a pre-sentence report under subsection 1 of the and the prosecution can also offer sentencing options at this time. From Teblanche. Murder consists in the commission of an unlawful act with the intention of killing another human being. From ISIS Crime Hub. In terms of synopsis of biographical details, it's from Ms. Sindisiwe Manqele. She's currently 27. Age at the time of the offence was 26. Her date of birth is the 20th of the 2nd, 1989. Her education is she's got grade 12. Case number, charges of murder and previous convictions, none. Sources of information, once again, Ms. S. Manqele, Ms. B. Nawa, Mr. Malaka, Ms. Vilakazi, Mr. Scooter. In terms of the pre-sentence report, we start off with the family of origin. Relationships with other persons begin with our experiences as a child. Within this context, understanding an offender's childhood is seen as critical. Barron, Bryan and Bronscombe state that the interactions of caregivers and the quality of the interactions determines the child's interpersonal actions and attitudes as they progress from childhood through adolescence and adulthood. Criminologists understand that the family is the starting point of a child's development, the family being the most fundamental institution in a child's formative years. The development of a child revolves around emotional and intellectual intelligence, moral and value development, and their ability to develop socially. Children within their family learn socially acceptable ways of dealing with frustration, conflict, personal needs, authority, and rules that make up societal norms. Attachment styles develop with caregivers, and this relates directly to the feelings associated with security within interpersonal relationships. From attachment, two basic elements are developed: self-esteem and interpersonal trust. Self-esteem is connected to the emotion of self-worth, feeling of being loved and of being of value. Or the opposite, where a child feels that they are unloved, unimportant, and have no value. Interpersonal trust narrates the ability to perceive people as trustworthy, dependable, and reliable. Or the opposite, where a child views people as untrustworthy, undependable, and unreliable. From Baron et al. Miss Manqele was born in Newcastle, KwaZulu-Natal. She was the last born of 4 children. She had 2 stepsisters that passed away when she was very young, and a stepbrother who was 12 years older than her. The family moved to Johannesburg before she started primary school. Her mother was a pastor and her father a policeman. Miss Manqele describes her relationship with her parents as very close. My parents and I were really close. We were friends and not just daughter parents. The family unit while she was growing up included her brother, who resided with them. She reported that there were no negative memories relating to her family and her childhood. She stated, "I had a very happy childhood. I had lots of friends and a great family." This was confirmed by Ms. Nawa, who has known her since primary school. She stated, "Sindisiwe was always the pretty, outgoing and popular girl at school." Ms. Nawa stayed with the family for a while and confirmed that the relationship between Ms. Manqele and her parents was very close and loving. For Ms. Manqele, the passing of her brother in February 2008 and her mother in August 2008 was devastating. Ms. Manqele stated that she lost 2 of her best friends in 1 year. Losing both her father and grandmother in 2015 was an added weight. She feels alone and finds it difficult to cope with losing her whole family at such a young age. Ms. Manqele currently lives with her aunt and 2 cousins who were adopted by her mother when their parents passed away. There are no obvious chromogenic factors relating Ms. Manqele's childhood. Rather, it appears that the nuclear unit that she came from was loving, stable, and a place wherein values and morals were fully developed. In terms of education and workplace experience, Ms. Manqele attended Sefeking Primary School in Leeuwkop. She did very well in primary school scholastically which is consistent with coming from a supportive and interested family unit. Ms. Manqele went on to complete a grade 12 in 2007 from Minerva High School in Alexander. As in primary school, she applied herself academically. She was chosen as one of the best 10 students and had the opportunity to meet Nelson Mandela, Hugh Masekela, and the Minister of Education at that time. Both Ms. Manqele and Ms. Nawa attested that she was very popular and had a big friendship circle. She was the one who everyone came to with their problems. Ms. Nawa attributes this to Ms. Manqele always being very glamorous and having beautiful stuff. Ms. Nawa feels that she has a very assertive personality, makes sure her voice is heard, and has a very realistic view of life. Ms. Manqele played a bit of tennis in high school and had no behavioral problems. After completing grade 12, she spent a year working as a model for a friend's mother who had a modeling agency. In 2009, she traveled to Ireland to try and get away and rebuild her life after the trauma of losing her mother and brother. From 2010 to 2012, she studied travel and tourism, and in September 2013 to September 2014, studied her honours in business studies at Griffin College in Dublin. Physical and mental health. Ms. Manqele reports that she was healthy as a child and adolescent. There were no complications with her birth that she is aware of. As an adult, she has been healthy but is currently taking medication for anxiety, Emidrol, and sleeping tablets PAC since the incident. She states that she has never taken any depression or anxiety medication before. Ms. Manqele feels tired and fatigued from not sleeping enough and overthinking everything. In terms of the effect of the offence, during the interview with Mr. Malaka, it became apparent that the impact on the victim's family is substantial. Not only have they lost their brother, father and son, but their breadwinner as well. The family also feels that Ms. Manqele should have approached the family through the elders after the incident to tell them that she didn't mean it. Mr. Malaka stated that the family does not bear a grudge against Ms. Manqele. The family is finding it difficult to find closure as they are still unsure of what really transpired the evening of the incident. Unfortunately, Mrs. Habedi was unwilling to discuss the impact with me after contacting her. I tried to telephonically as well as through text message contact Mrs. Habedi for input after receiving her number from Mr. Scooter. I had a telephonic conversation with Mr. Scooter, who advised that he had spoken to Mrs. Habedi in connection with me contacting her. Although a victim impact statement is not part of a pre-sentence report, it does assist the report writer to understand the impact of the offence on those involved and provide direction for sentencing recommendations. It is understandable that through traumatic times, often the victim's family are emotionally vulnerable and therefore no further urging was done. In terms of evaluation of the accused, Ms. Manqele was able to logically reply to questions put to her, although she became emotional when talking about Nkululeko and their relationship. She wishes she had gone back to Ireland in February 2015 when she was supposed to. She explained that Nkululeko requested her to stay as they'd been through a difficult time in January and he wanted to spend time with her. It is very clear that she feels very remorseful for what she has done. She stated, "I am devastated. I feel so guilty that my actions have taken him away from his mother and daughter, who he had such a close bond with." Ms. Manqele feels very scared whenever she thinks about the fact that she killed somebody. She admits that it has affected every part of her life. She stated, "I used to be very ambitious and have lots of plans for my future. Now I just hide because I think about it all the time. I can't sleep and am constantly trying to understand how this happened in my life." She relates how she used to be full of life and that she had a very busy social life, went to the gym, worked and studied, where she now finds it difficult to concentrate, forgets things and would rather be alone. She talked about people feeling sorry for her. This makes her feelings worse. She stated, "I don't like people feeling sorry for me. I don't deserve their pity." Ms. Manqele no longer wants to go out and prefers to spend time at home with her family. This was attested to by Ms. Twana, who said, "Sindisiwe used to be very open, but since the incident she has built very high walls around her. And although I feel I can still go to her with my problems, it is like she has become very hard and has given up on life." Ms. Twana also alluded to the fact that Ms. Manqele has become even more assertive than she used to be, almost like she is not willing to let anyone know how she is feeling. When individuals are exposed to a particularly traumatic experience, they go through a post-traumatic adjustment phase. The symptoms may vary, but according to the DSM-5 classification from Sue, and Sue, the following may be experienced. Experiencing the event in disturbing dreams or invasive memories which keep recurring without any control on the part of the victim. Emotional deadening or avoiding stimuli that is associated with the trauma experienced. heightened autonomic arousal, which is strong responsibility to stimuli. Other symptoms can be described as dissociation, depersonalization, detachment, and possible feelings of numbness. Post-traumatic stress occurs after exposure to a specific extreme stressor. Other requirements are that the person is exposed to a life-threatening serious injury or perceived serious injury situation. Often individuals experience difficulties in everyday tasks and have a lack of concentration. The smallest mistakes that an individual makes can cause anxiety and overreaction, especially when attributed to internal attributes. It is important to note that Ms. Manqele feels very disturbed by the incongruence she now experiences. Her view of self post the incident is not congruent with how she perceived herself prior to the incident. Ms. Manqele said, "I have caused so many people so much pain. I don't understand who I am anymore." This response is predictable when an individual performs an act that goes against their moral and value judgment. Due to Ms. Manqele coming from a home where her mother was a pastor, it seems to add extra feelings of guilt and shame. The impact on her family, her aunt and cousins, as well as her friends, has been enormous. Everyone who knows her is affected by the incidents. She stated, "My friends and family walk on eggshells as they are not sure what is going to happen to me or how to help me." In terms of the crime explanation, when trying to understand crimogenic factors and social behavior that has led an individual into crime, it is imperative that we understand that it is a multifaceted and complex inquiry. In understanding the environment, individual and social experiences, as well as the patterns that lead to the criminal event, it is important to look at the individual holistically. Although prediction of future crime, which is the risk factors, often relies on the consistency of past behavior, there needs to be a deeper individual inquiry in order to provide a factual representation of the person being evaluated. To Blanche has the following to say about criminology. Criminology, broadly speaking, studies crime, criminals, victims, punishment, and the prevention and control of crime. The most important role of the criminologist is to study, interpret, and explain crime. The emphasis of criminology used to be on explaining why criminals act as they do, but now it is on explaining the results of sentences. This makes it all the more important for judicial office to take note of the research of criminologists. Criminological theories have been developed to assist criminologists to explain crime from an empirical standpoint. Theoretical understanding allows for deeper insight into models of behavior that happens in relation to environmental stresses, personality, and social relationships. An integrated approach is often taken in order to provide an understanding of criminal acts over time and place. The criminological explanations are not done to direct blame at another party or make excuses for the offender's behavior. Rather, it allows us to understand the formation of behavioral patterns of the individual being assessed. In terms of relationship dynamics, Ms. Manqele started dating in high school. She had 3 long-term relationships over the years. Ms. Manqele explained how both her former boyfriends were abusive, both physically and emotionally. She initially met Nkululeko when she was in grade 12. They started dating, but when she found out he was married, she broke off their relationship. She then started dating another man from 2007 to 2009, who, although he lived in Spain, she saw frequently. They both travelled and met in South Africa and in Europe regularly. After her mother passed away in 2008, he became very abusive and would often taunt her by telling her that she was now an orphan. She feels that their relationship can be defined as a power relationship, where there was a constant struggle for power, as she is very independent and has a strong personality. She ultimately broke up with him and went to Ireland to get distance with him and deal with her mother and brother's passing. "I could not handle the abuse on top of my anguish." Ms. Twale said, "I would meet with Sindisiwe and she would have bruises. Often she would phone me in the middle of the night crying during this relationship. I felt helpless as I did not have money to go and see her when she was overseas with him." Ms. Manqele remained single for some time, and on one of her trips back home from Ireland in 2010, made contact with Nkululeko on Facebook, but did not meet with him. When she returned to Ireland, she met her next boyfriend and was intimately involved with him from 2010 to the beginning of 2013. This relationship was also very abusive. Once again, she felt she was caught up in a power struggle relationship and that he was very possessive, jealous, and dominating, although a very nice person. Ms. Manqele explained, "I feel that I am maybe jinxed or something because I keep finding abusive partners." In mid-2013, after breaking up with her boyfriend, she once again contacted Nkululeko when she came to South Africa for holidays. They spent a lot of time together and started dating. She returned to Ireland to continue studying, and they communicated through Skype, texting, and telephone calls. She described it as a committed relationship, even though we lived apart. They spent plus minus 2 weeks physically together each time she came home. She stated, "I seem to always be drawn to abusive relationships that were characterized by jealousy, possessiveness, and a desire to control me. Nkululeko was never physically abusive to me, and I thought I had finally found a good relationship." Ms. Manqele stated that until that night, he had never been physically abusive to her. He had fights with guys but never touched her. She stated, "I think what really stuck with me was my shock. It was so out of character for him to be violent towards me, and it frightened me." Ms. Manqele describes their relationship as very good, but that it was very rocky because of having a long-distance relationship. Ms. Twala said, "Sindisiwe really loved him. Their relationship was not steady though." In terms of the criminological explanation for the offence, social learning theory is one of the major theoretical frameworks whereby human behavior can be understood. Bandura, one of social learning theorists, defines it as behavior is determined by the interaction of three factors: the person, the situation, and the behavior that takes place in that situation. From Meyer, Moore, and Viljoen. From Volt, Bernard, and Snipes, knowledge and habits are formed through individual experiences within their social environment. The individual has two sets of learning approaches, namely instinctual behavior and learned behavior. Aristotle, as early as 384 BC, stated that all knowledge is acquired through interaction and experiences within our social world. Social learning theory links attitudes and values to the influence of general and specific definitions. General definitions would include broad beliefs about conforming behavior that is influenced principally through conventional norms, as well as religious and moral values, from Akers and Sellers. Specific definitions are seen as those that orient a person to particular acts or a series of acts, also from Akers and Sellers. The main premise behind this notion of definitions is that the greater the number of definitions favorable to deviant or criminal behavior, the greater the likelihood that an individual will take part in that type of conduct. Social learning theory also accounts for conforming behavior to the extent that the greater the number of definitions favorable to conventional norms, the less likely an individual is to engage in deviant or criminal acts. It is conceivable within this understanding of social learning that an individual could adopt conforming attitudes and values about certain behaviors, while at the same time develop attitudes and values that justify or excuse some types of non-conforming behaviors. Ms. Manqele grew up in a home that was characterized by good morals and values. The experiences within her intimate partner relationships were, however, very abusive, and violence within intimate partnerships became a norm. Cognitively, definitions favorable to deviance provide a mentality that makes one more agreeable to commit the act when the occasion occurs or is created. Behaviorally, they have an emotional impact on the commission of deviant behavior by acting as an inner discriminative provocations, from Akers and Silverman. It is important to note that an individual who has acceptable, favorable, or neutralizing definitions of deviant behavior does not necessarily have to act on them. Although Ms. Manqele had been in previous abusive relationships, she had not committed any criminal acts. The situation in which the current offence took place must have been distinctly different. Consequently, the context under which these behaviors take place is redefined in light of these favorable and neutralizing definitions. Repeat victimization that Ms. Manqele experienced in her previous relationships can be understood as target antagonism, which looks at personal characteristics that increase the risk of victimization. These characteristics arouse jealousy, anger, or destructive impulses. Ms. Manqele, being a strong and independent woman who cannot easily be controlled, possibly ignited feelings in her partners that both parties had no insight into. The manner in which we deal with relationships comes through our experience of past relationships. Certain individuals are more prone to being stuck in cyclical violence within intimate relationships. From Bartal and Bartal, note that being violently victimized by an intimate partner over long periods results in emotional reactions and psychological scars, which can be described as distinctly different from those which may develop after violent victimization by a stranger. Although murder may be a very alien concept to most individuals, it largely is a product of circumstances that a perpetrator finds themselves in. Donald Black in Brown, Espenson and Gijs claims that murder is characteristically a form of self-help that individual utilizes in order to resolve their situation at that time. Poiter in Brown et al. Contends that every human being has a dark side which is hidden behind masks of unpredictable complexity Everyone has a reservoir of rage, dissatisfaction, self-loathing, unhappiness, and intolerable feelings of inadequacy. It is quite common in victim-offender interactions that the two parties are familiar and have had a series of altercations previously. Davis and Snyman explained that situations can create violent interactions, especially when concerning accusations of infidelity, arguments over money, drunken brawls, and insults. Davis and Snyman go further to explain how quarrels can develop into life and death situations through a series of situations and stages. Arguments that start off relatively innocently escalate as both parties attempt to win the argument. Carmen regards this readiness to resort to violence in order to settle a disagreement not as a psychological issue, but rather a learned behavioral pattern. Carmen explains how alcohol consumption has been consistently related to interpersonal conflicts that lead to fatal consequences. The selective disinhibition theoretical perspective explains that if one or both parties, that is victim and offender, drink heavily, their judgment becomes clouded, and that they are more likely to misinterpret each other's intentions, cues, and actions, and behave in a less controlled manner. From empirical study results, it was found that up to 86% of homicide offenders had consumed alcohol at the time of the offence. From Bartel and Bartel. Davis and Snyman contend that under the influence of alcohol, individuals tend to react out of character and become argumentative, aggressive, and quarrelsome. Bartel and Bartel report that reciprocal aggression generally happens when one person is provoked by aggression from another party. This reciprocal aggression happens under anger-inducing conditions, such as perceived threats, insults, physical attacks, or one's own failure, whether they are considered real or perceived. Fontaine calls it reactive violence and defined it as hot-blooded, emotionally charged, and enacted quickly to harm the provoker or to defend oneself. It is important to understand when identifying motives for murder the extent to which injuries by the offender are committed to the victim's body. From Cantor and Young's, the destruction of person will differ between anger and emotion. In this case, there was only one stab wound, which shows an emotive action. If the action consisted of multiple stab wounds, it would clearly have indicated anger and revenge. Many offenders who display reactive violence have a strong hostile attribution bias, which promotes violence when they perceive provocation or threats. From Bartel and Bartel. This can once again be linked to Ms. Manqele's previous relationship patterns, in where she was victimized by her intimate partners. She stated, "I don't think it was the alcohol. We had been having arguments over money and other things for some time. Alcohol and anger meant we said things we usually wouldn't have said to each other." Although Ms. Manqele stated that she does not think that alcohol was the reason for the stabbing, it certainly played a part in the escalation of previous quarrels and the deviation for previous conflict resolution strategies. From Bartel and Bartel note that murder is situation specific, that it depends on a number of things, including the availability of a weapon, the amount of alcohol consumption, the nature of the provocation, the circumstances, the motivation, and the emotional and mental state of the offender at the time. Personal cause murder, according to Bartel and Bartel, is generally committed when an individual is under emotional cataclysm, conflict, passion, and is usually triggered by a general altercation or argument. In terms of sentencing is the privilege of the Honourable Court. The criminologist's function is to provide as much information to the court with regards to the interpretation of gathered facts. The seriousness of this crime makes it relatively easy to elicit emotional responses, but fortunately the law is very defined and based on fact rather than emotion. In order for sentencing to take place, there are three legs of the triad that must be looked at. Number one, punishment. Punishment must contain elements of discomfort as it is designed to inflict suffering. From Toy Blanche. Punishment must be of such a nature that it fits the offence, the outcome being punishment for the crime that was committed. When looking into punishment, we need to consider the crime component. The court has to, in each individual instance, take the offender's particular crime and its seriousness, and not make generalized assessment of the severity of certain kind of crimes. From Teboho. An important step in deciding the form or type of punishment needs to be fully understood, as there is a vast difference between punishment and sentencing. Care must be taken that a deserving sentence is handed down rather than being punitive for the sake of it. With regards to discretion, sentence has to be handed down on the basis of the sentences the judicial officer may impose in the case before them, and of all additional information necessary to make the imposition of an appropriate sentence possible, from Teboho. The object of sentencing is not just to satisfy public opinion, but to serve in the public's interest. Number 2, retribution can be defined as the response of society to the transgression of the offender and the resulting consequences of the offender's behavior through punishment for the unlawful activity, from Holland. Making a distinction between retribution and deterrence within the criminal justice system is important. Deterrence can be defined as the intentional punishment for offenders that seeks to create behavior change within an individual to ensure future compliance with the law, from Holland. Number 3 is rehabilitation, is aimed at improvement of the offender, and the outcome is to ensure that the offender understands that they have acted in error and need to seek ways of ensuring that future behavior is law-abiding. It is clear from Teboho that incarceration has shown almost no potential to rehabilitate offenders, particularly long-term imprisonment. The opportunity for rehabilitation lies within the offender. It is they who must actively seek assistance. In terms of risk factors, in sentencing, the measured risk that an offender may present to society is a significant aspect. Risk involves not only the possibility of an offender reoffending on reintegration, but also in terms of alternative sentencing options. Risk assessment is a way of filtering groups of offenders to see who is a greater risk or lesser risk within groups, from Kemshal. This is known as the risk principle, and although it can never be considered 100% accurate, helps people compiling risk assessments to consider who is more likely to reoffend. Static factors are based on history of the offender over the longer term. These static factors relate to personality characteristics, attitudes, and prior history of antisocial behavior, family background, and intellectual functioning, early age onset of criminality, ethnicity, gender, and behavioral problems. It is clear that within the static factors, Ms. Manqele falls on the low end of risk. Her family was stable, and she showed no antisocial behavior. Her intellectual functioning is seen as high. There were no early age criminality factors. Personal characteristics through her wide social circle show she is a functioning member of society. Dynamic factors are also known as crimogenic need factors and relate to factors that vary quickly over time and mostly reflect internal states of temporary circumstances of the individual. These would include factors like marriage, employment, self-esteem, impulsivity, etc. Ms. Manqele would once again be considered low risk, but interventions within this area would enhance her ability to develop emotionally. In terms of mitigating factors, it is important that the judicial officer has the opportunity to understand mitigating as well as aggravating circumstances when planning sentencing options. When looking at mitigating circumstances, whether or not an offender is the first-time offender is important. In McDonald, JP, in S v. Wood, the question of an appropriate sentence in the case of a first offender almost always presents a judicial officer with problems of a particular difficulty. The publicity of the trial, his exposure as a criminal, the far-reaching effect of imprisonment on his social, family, and economic life are, in the case of a first offender, aspects of punishment which should never be overlooked or underestimated, from Teboho. There is no doubt or contestation that Ms. Manqele is a first-time offender and that she is considered a very low risk for reoffending. The age of the offender is important in terms of understanding emotional maturity levels. Ms. Manqele, although having experienced a lot in her lifetime, seems to have a low emotional capacity within her intimate relationships. The mental and emotional state of the offender at the time of the offence must be understood. Ms. Manqele's case shows that there was heightened emotional arousal that was coupled with the effect of intoxication. The fact of this being a mitigating circumstance is determined by the circumstances of the case. It is common knowledge that most murders are committed while a person is intoxicated and their mental faculties are impaired. It is also clear from the testimonies of the witnesses that emotions were extremely heightened preceding the incident. In S v. Williamson, Viljoen J. stated, "It is true that our criminal law goes out from the premise of indeterminism. That means that every person is presumed to have a will, which he not only can direct as he wishes, but which he is obliged to direct in such a way as to conform with precepts of the law and order. But our law also recognizes that there may be factors, deep-seated factors, which may urge or impel a person to act asocially. Such a person who is subject to such urges or impulses should be treated in an endeavor towards the correction of these antisocial tendencies rather than be punished. For such a person, incarceration should only be the last resort and should only be applied if the community cannot otherwise be protected. Remorse is another very important aspect of mitigation. Defining remorse may sometimes be difficult, but the effect of the offence on the individual's life, as well as insight into their part of the criminal act, allows a degree of understanding of the remorse felt by that individual. It is important to determine whether the remorse expressed by an offender is indeed remorse or whether it is guilt. In Ms. Manqele's case, it is without a doubt that she displays remorse. Lack of premeditation and planning. Based on the criminological evaluation of this particular case, it would appear that it was an impulsive decision on the part of the accused within the environmental situation and stresses she found herself in. In terms of victim precipitation within this case, concerns the escalating emotional state of both victim and offender during the hours leading to the offence. It is probable that Ms. Manqele would not have committed a criminal offence had the escalation of conflict between herself and the victim prior to the offence not presented themselves or presented to a lesser degree. In terms of rehabilitation, it is seen as highly probable. The insight that Ms. Manqele displays in terms of her role in this incident is evident. In terms of aggravating factors, one has to look at the seriousness of the crime, the impact on the family of the victim, as well as the financial impact in the case where the victim was the breadwinner. Through interviews with the investigating officer, Mr. Malaka, it is very evident that the family has suffered both emotionally and financially due to the actions of the accused. Any crime that is committed with a weapon should be viewed in a very serious light. The violence perpetuated during the commission of the crime should also be taken as an aggravating factor. In terms of sentencing options, to provide guidance to the judicial officer through insight into an individual to the court is part and parcel of a criminologist's function. It is with respect noted that the Honourable Judicial Officer has the decision in terms of issuing a sentence to the accused. The need to balance punishment and rehabilitation within our current climate can be a difficult position. There is a definite shift from purely punitive approaches to more community-based sentencing options that deal with the rehabilitation of the offender within a setting more geared for growth. That being said, there is also a need to ensure that people do not view the judicial system as lenient. Due to the high crime statistics within South Africa, there is an upward trend of using high-profile offenders as deterrents for future criminals. The balance that needs to be maintained is of utmost significance. Should incarceration only benefit the judicial system and not the offender, it is likely to increase the rates of recidivism, thereby creating a greater risk to society. From a PhD study in Canada, the following results were produced. 50 studies dating from 1958 involving 336,052 offenders produced 325 correlations between recidivism and A, length of time in prison and recidivism, or B, serving a sentence versus receiving a community-based sanction. The data was analysed using quantitative methods, i.e. meta-analysis, to determine whether prison reduced criminal behaviour or recidivism. The essential conclusion reached from the study were: 1. Prisons should not be used with the expectation of reducing criminal behaviour. On the basis of the present results, excessive use of incarceration has enormous cost implications. And number 3, in order to determine who is being adversely affected by prison, it is incumbent upon prison officials to implement repeated, comprehensive assessments of offenders' attitudes, values, and behaviour while incarcerated. And number 4, the primary justification of prison should be to incapacitate offenders, particularly those of a chronic, high-risk nature, for reasonable periods and to exact retribution. This study highlights the belief that incarceration changes behaviour. It is unfortunately not that simple. Interventions change behaviour. In South Africa today, there are simply not enough individualised programs, access to behavioural modification programs, psychologists, or funds available to deal with the overcrowded populations within the correctional centres. The exposure many offenders experience may have the opposite effect, when offenders who had no criminal tendencies develop them through exposure to career criminals. With due respect to the court, there are only 3 conceivable sentences available to the court with regards to this case. Number 1 is imprisonment in terms of Section 2761B of Act 51, 1977. Imprisonment from which a person may be placed under correctional supervision in his discretion by the Commissioner, Section 2761I of Act 51, 1997. And number 3, correctional supervision, Section 2761H, Act 51, 1977. In terms of imprisonment, this option is certainly a possibility with the court. The need to appease society, particularly in this case with extensive media coverage, is seen as high. The importance of ensuring that direct imprisonment is the best option in terms of this case needs to be explored. The notion of direct imprisonment as the only option within current climates of South African correctional institutions, needs to be understood in terms of the state of correctional settings. From Teboho, there is a perception that life in prison is equated to a hotel, where prisoners get free food, clothing, and that they get to watch movies and television all day. Of course, nothing is further from the truth. It is almost unthinkable that any of these commentators have ever been inside a prison. The current overcrowding in most correctional centres creates an unbearable situation where few or no programs are being rendered that work on the rehabilitative aspect of the offenders. Offenders have no basic rights, such as going to the toilet privately, and cells are housing a larger and larger number of individuals. The main assertion being that due to the offender's action, direct imprisonment is seen as the only alternative. There is cause to consider alternative sentencing options, in this case due to the substantial and compelling circumstances of this offence. In S. v. Carolio, 2006, at 87 HR, the court concluded, Section 51(3)A furthermore specifically provides that if the court is satisfied that substantial and compelling circumstances exist which justify the imposition of a lesser sentence than that prescribed, it shall enter those circumstances on the record of the proceedings and may thereupon impose such lesser sentence. Murder generally carries a minimum mandatory sentence, but this does not stop a judicial officer in providing a discretionary sentence. In terms of discretion, it is noted in S. v. Toms and S. v. Bruce. Smallberger J.A. gives two reasons for the existence of discretion. Such discretion permits a balanced and fair sentencing, which is a hallmark of enlightened criminal justice. The second, somewhat related principle is that of individualization of punishment. In Plant's 2007, the optimal combination for any judicial officer should be the principle of proportionality, an optimal combination of restoring the rights of victims, protecting society, and providing the offender the opportunity for a crime-free life. In terms of Section 2761I, this type of sentence is considered highly recommended when it is recognized that imprisonment is punitive in nature, but where long-term imprisonment is considered unnecessary in terms of rehabilitating the offender. In S. v. Fatay, 2001, 488 DI, the Honourable Court stated the following with regard to substantial and compelling circumstances. For the circumstances to qualify as substantial and compelling, they need to be exceptional in the sense of seldom encountered or rare. Need not be exceptional in the sense of seldom encountered or rare, nor are they limited to those which diminish the moral guilt of the offender. The ability of the punitive aspect of incarceration to be coupled with a non-custodial sentence offers an offender the opportunity to experience punishment as well as the substantial likelihood of rehabilitating the offender. Correctional supervision, according to Blanche, is described as an appreciable sentence, suitably severe even for serious crime. It is not a soft option, and it is substantial and effective punishment with a high punitive value, the advantages of which are numerous. The offender, instead of being alienated from the community, can establish restitution between victim and offender, access resources for rehabilitation, while being monitored, affording protection to society. In terms of correctional supervision, Blanche 2007 states that although rehabilitation is not a likely outcome of any punishment, the rehabilitation of an offender is, logically speaking, a more likely outcome of correctional supervision than of imprisonment. In S. v. Ndaba, Kriegler AGA alluded to the fact that the flexibility of correctional supervision lies in the possibility of setting a truly individualized program for an offender when sentence is initially imposed. Again, in S. v. Labuschagne, 1995, it is now possible to impose a severe punishment and to serve the interests of the community by imposing a deterrent and strict sentence other than imprisonment. The need for individuals in conflict with the law to maintain community ties is a very well-researched topic. The isolation and degradation of incarceration has no beneficial effect on an individual. From Blanche 2007, since the name given to the crime is not as important as the seriousness of the specific crime with its own peculiar facts and features, correctional supervision has already been considered appropriate in cases of murder, rape, public violence, and armed robbery, which under normal circumstances will be punished with imprisonment. The basis for not considering correctional supervision is generally in the interests of society where an offender is considered a danger to society. In terms of my recommendations, Ms. Manqele does not display characteristics that are criminal in intent. She furthermore is viewed as a very low risk for reoffending. Although Ms. Manqele deserves to be punished for her actions, it is also in the best interest of society that being punished that beyond being punished, she has an opportunity to once again become a functioning member of society. When viewing Ms. Manqele's personal circumstances surrounding the motive for her offending, it can be viewed as a triggered response to an emotional stressor situation. She does not display any characteristics of deep-seated criminality for which incarceration for a long period is necessary. Incarceration will be very destructive, and the likelihood of Ms. Manqele being able to contribute to society on her release in a functional manner unlikely. It is common knowledge that the correctional institutions are a breeding ground for future criminality. The negative socialization with hardened criminals over a long period is likely to become entrenched negative behavioral patterns, and this is exasperated by the inability of an offender to find suitable employment opportunities upon release. While the acts committed by Ms. Manqele cannot be excused or condoned, her personal situation, state of mind, and the context within the crime was committed needs to be sincerely considered. The ability of Ms. Manqele to continue her studies under house arrest, surrounded by a family support structure, while undergoing therapeutic interventions, giving back to the community through community service, and being able to maintain positive social interactions would be deemed a fit sentence. It would be recommended that Ms. Manqele be instructed to seek inter alia consultation with both a psychiatrist and a psychologist to ensure that a holistic psychosocial intervention takes place.
And you confirm the correctness of the report?
I do.
And you abide by its content?
I do.
I'm not stated indicated. I beg leave that it be the report is accepted as
Thank you, my lord. Mr. Haley, I'd like to refer you to page 7 of your report. You make reference there to the development of the child. Am I correct to infer from the totality of your report that there was not really anything from her childhood, her upbringing, her background that really contributed to her committing this specific offence?
That's correct. As far as the risk factors from her childhood, there was nothing that could possibly be substantial.
There was evidence presented in respect of the psychologist, in respect of the fact that the accused actually had a strong independent nature, such that at the age of 16 years she already moved from a parental home to stay with somebody else to complete the studies. Do you confirm that in fact she is a strongly minded, strongly willed person?
Well, obviously I'm not a psychologist, but what I can comment on is the fact that I triangulated the information. So both Ms. Nwala, her lifelong friend, and Ms. Manqele both stated that she was very determined and a person with a strong will.
On page 9 of your report, with respect to the education and workplace experience, you referred to Mrs. Nawa, and the interview you had with her, that she stated the accused was very popular and had a big friendship circle. She was the one to whom everybody came with their problems. And Mrs. Nawa attributes this to Mrs. Manqele always being very glamorous and having a beautiful stuff. She also has a very assertive personality. Would you say that the accused was a person who loved attention and maybe seek it more than the normal type of person?
Obviously, after just having very short, extensive interviews with Ms. Manqele, but obviously not knowing her for a very long period, I cannot state what her behavior incited when she was younger. I can only take from what I was told by Ms. Manqele and by Ms. Twana. So, unfortunately, like I said, I'm not a psychologist. I can't answer on that fact.
The reason I'm asking this, because there were evidence led by the state that on the night preceding the incident, that there was an incident between the deceased and one of his exes, as a result of which the accused became jealous and started acting up. And that was possibly the reason that led to a fight between the accused and the deceased. Would you state that jealousy on the part of the accused played a role in the commission of this offence?
Unfortunately,
First of all, there was no such determination in the court's finding, in the trial finding, that the assertion made by my learned friend in fact prompted the accused to commit the offence. And as it were, the determination of the Honorable Court is that the accused acted in private defense, however, she exceeded the bounds thereof. Those other emotive and decorative adjectives to try and portray her as this jealous and attention-seeking individual is rather misleading, and I do not think it is fair to make that proposition to the witness to comment on.
My vote, that evidence was never rejected of the state witnesses that in fact the accused acted in a jealous manner in the events preceding the incident. The question simply put is, from his understanding, the explanation given by the accused, could jealousy on the part of the accused have played a role in the commission of the offence?
I still stand by my objection that the Honorable Court had an opportunity to condemn and make a factual finding as to whether that is in fact the fact or not, and the Honorable Court's judgment does not cover that, and it cannot be put as something that has been proven and about which the witness can be called upon to comment. And I have deliberately gone through the record seeking specifically such findings, and there is nothing on your worship's record judgment. In fact, what is correct is that there was such an allegation, and that allegation was dealt by the defense in opposing. However, the Honorable Court did not find that it has been proven beyond a reasonable doubt, and in fact constituted part of the eventual findings that led to a conviction as it stands today.
I do not know if Mr. Nkululeko, if you have had sight of the judgment itself.
Unfortunately, I have not had sight of the written judgment because we are struggling to get it from what is this, Africa, but because of technology, we had the benefit of YouTube amongst others, and there is your Lordship's full judgment and live for that matter, and I followed it.
Yeah. You see, in my judgment, I refer to the cause of the altercations between the accused and the deceased. Then I said such wrangles between the two of them and altercations can only be inferred by the court and anyone who heard them to originate mainly from extreme mutual jealousy as well as from the deceased's apparent parlous financial status. I use those words exactly. Now, jealousy was triggered by the presence and actions of third parties, both male and female, especially at a locality such as the Sands. Then I gave an example. For example, the conversation with the deceased and the dancing of his ex-girlfriend, Kiabetu, also known as Kia, got the accused irritated. Now, that is in the beginning where I gave a background of the clash. This is just what happened before the collision which took place in the room in which the deceased was killed.
I appreciate that, my Lord, but my Lord's final finding is as follows, that the reason the court is of the view, or in fact finds that the accused is guilty, is because she exceeded the bounds of self-defense, not because she was jealous. It's because she was defending herself, and then she overstepped the boundaries that are drawn by the law. Nothing had to do with jealousy on her part, for that matter. And that is why I'm objecting to this proposition that is now being put to the witness as if now this has been found to be the instance. Otherwise, your Lordship is correct in that in your Lordship's summary and repeating of what was put before court, it was actually stated, but it was not your Lordship's finding.
That is so. It is one thing to use it for other purposes, but it is another to say it was mentioned and passant during the judgment. Mr. Skritter?
Yes, my Lord, the point is that what was put to the witness is that there was evidence before this court that jealousy, also on behalf of the accused, played a role in the altercation that took place.
Let me read the exact words which I used in my judgment, because I've got the judgment. On the authority of the Atwood and the Ngomani cases, supra, and having applied my mind not only to the merits and demerits of the evidence of the state and the defense witnesses, but also on the probabilities and improbabilities of the evidence in its totality, I am convinced that the version of the accused is not reasonably and possibly true, and that it has to be rejected by the court as false. More particularly in that there is no reasonable relationship between the deceased's alleged attack and the defensive action of the accused. Stated otherwise, the court finds that the accused in her private defense exceeded the limits or bounds of such defense by plunging the steak knife into the chest of the deceased, thus intentionally and unlawfully killing him. That's what I said. That's what I found. This is what I said. But I never said I find that her jealousy exceeded that of the deceased, or her jealousy is the cause of the whole thing. I never said that.
Yes, my Lord, but that was not.
But giving a background at the beginning, when I gave a background of the clashes between the two, I did mention it.
Indeed, my Lord, if I understand the judgment of this honourable court correctly, it is indeed jealousy on behalf of the accused as well as jealousy on behalf of the deceased that led to the argument that took place. And that's the point I'm trying to make, my Lord, not that there's a context within which this fight which led to the deceased death took place, my Lord.
Let me read further about what I found, or the bounds of self-defense that she exceeded by plunging the steak knife into the chest of the deceased. This lends credence to the evidence of the forensic pathologist, Dr. Pandu Mahulu, that the nature of the force used for the type of injury sustained by the deceased was consistent with a considerable force which fractured the left fourth rib and penetrated the pericardial sac and right ventricle of the deceased heart. Now, obviously, what Dr. Mahulu was saying here, she was describing the force that was used to stab the deceased. And it has nothing to do with jealousy, which is either in the deceased or in doesn't reflect anything on the jealousy, but it only shows that she used great force in plunging this knife into the chest of the deceased. So you may argue, you may rephrase what you're saying or what you intend saying about jealousy. But all I said in the judgment was that their love relationship was characterized by jealousies and altercations and some such things, and it is true. And I even mentioned different localities, about 5 different localities, where this jealousy and altercations were playing themselves out. And you can actually enumerate the places where all this happened until it reached fever pitch in the room of the deceased and where the deceased was stabbed. So I never said I find that is the cause of it. I've read to you out what the cause is here.
Indeed, my Lord. That is well understood. The point is that the impression that is being created is that the only person that was jealous in this matter was the deceased. And that was the cause of the altercation that took place, and then that led to the ultimate incident. The point I'm trying to make, well, the question I posed to the witness, my Lord, is simply that it was not simply only the deceased, that there's evidence before this court, and indeed the court found in the judgment that there was also jealousy on the side of the accused that led up to this argument that took place. That's basically the essence of it.
Yeah, their love relationship was characterized by mutual jealousy. Mutual jealousy. That's what I said.
May I then be allowed to put that to the witness, my Lord? Because that was basically the point I tried to make with the question.
Put your question straight, but don't just say that's what the court found, because that is something else.
My Lord, I never said that is what the court found. That is what my learned colleague suggested. I said my question was put to the witness that was the evidence presented by the state.
You are allowed to put questions to the witness as long as you rephrase your whatever ideas you have in you. You're living somewhere, I don't know, but just ask him what you want to ask.
Stanley,
and if you dwell on the jealousy, it's not going to take us anywhere, because there was mutual jealousy, as I said, that it was a relationship, a love relationship characterized by mutual jealousy. That is jealousy from Aliyunde, from all sides.
Indeed, my Lord, I'll keep it short. Mr. Ali, I assume you've followed the argument that took place here.
Yes.
Can you dispute the fact that there was mutual jealousy between the accused and the deceased prior to this incident?
Look, any incident that takes place involves 2 parties. An incident cannot happen with only one party. I was not there at the time. I've listened to the judgment as well, but it is not up to me to decide who was guilty and who was innocent. My role is to enable the court to understand what the criminological explanation for this type of offence is, to give them a holistic picture of the individual and what may have led to this offence.
You refer on page number 17 of your report, and there's a reference to Bartle, and Bartle had noted that being violently victimized by an intimate partner over long periods result in emotional reactions and psychological scars. Did you detect any psychological scars in the accused during your consultation?
Okay, once again, I'm not a clinical psychologist, and I wasn't there to assess her for her mental state. I was more there to understand possible risk factors and to understand her life history, which would display crimogenic factors, particularly on the static and dynamic side.
So you cannot comment whether there was any psychological scars?
Unfortunately, no, I can't.
On page 18 of your report, you refer to the consumption of alcohol. what is your finding in this specific matter? Did alcohol play a role in the commission of the offence or not?
One of the very important questions and one of the great determinants in terms of me asking Ms. Manqele questions surrounding the alcohol intake and things like that and getting her perspective was purely to understand from her perception and her insight into this incident. And I can only go, I wasn't there with him at the club that night, I wasn't a part of that, and there was no test done to determine how high the level of intoxication was. I can only go on what Ms. Manqele told me, and she stated that she didn't think that the alcohol had anything to do with the actual stabbing, but that it obviously had something to do with the argument and the escalation of the argument. I think the important part in understanding the intoxication and the effect was very clearly stated in my report in terms of how people may misconceive people's actions and reactions. And I think in a lot of cases, alcohol plays a big part in people underestimating or being unsure of what their partner actually intended. But as for her intake, I cannot comment on that. I wasn't there.
So you cannot say that the intake of alcohol affect her decision-making ability?
No, I can't state that.
On page 18 at the bottom, you also make the point that in this case there was only one stab wound, and then you move to the conclusion which shows an emotive action, and you put it in the context, or you contradict it to the fact that multiple stab wounds would clearly have indicated anger and revenge. That's correct.
If you look at the reactions and what this book that I actually took this reference from is in terms of violent offending and profiling. And one of the big determinants that criminologists, forensic people make when looking at a victim is generally in terms of what was the extent of the damage done to the victim, which generally brings them back to motive. So if you were to be profiling somebody, you would be looking for certain characteristics, and in that would be the amount of aggression that took place within that act.
Now, in this case, you also heard what the learned judge informed you or read from the judgment that there was a single stab wound, although this stab wound penetrated the heart. And the evidence before court is that the deceased immediately started losing any power, and he started to fall to the ground. Isn't it important to give cognizance to the situation in which such a single stab wound is inflicted? If a person immediately after the first stab wound falls to the ground, doesn't this argument then that further stab wounds would have indicated anger or revenge?
No, not particularly. A lot of cases, particularly when it's anger and revenge noted, you will find from pathology reports that people are repeatedly stabbed even after they succumb to their injuries. So I don't agree with that.
You indicated on page 22 at the bottom, paragraph 2 of your report, that the age of the offender is important in terms of understanding the emotional maturity levels. And then you conclude that this Manqele, although having experienced a lot in a lifetime, seems to have a low emotional capacity. What led you to this conclusion?
Well, I think it's very important when we look at dynamics within relationships. And in another place in my report, I stated that it is very difficult in terms of being stuck in cyclical violent relationships to withdraw from those. So generally somebody who has got a very mature emotional stance will be able to find the ability to move out of those kind of relationships. I think there were a number of stresses on Ms. Manqele during this period in terms of the loss of her mother and her brother, as well as being in previous abusive relationships, which could at any point contribute during that time to really not being able to deal correctly with the situation.
But on her own version, on 2 previous occasions, she herself ended those type of relationships.
That's correct.
So she was able to act properly and, how shall one say, maturely previously in those type of relationships.
Well, I don't think whether it's an extent of maturely or immaturely. I think that it's a factor of when we go into, I think, and all of us, we have behavioral or emotional patterns within our intimate relationships. We tend to end up going for the same type of person, seeking what that person is able to provide us. A lot of times it's because we are seeking something we don't have within ourselves. And that's in terms of our emotional maturity or not. Like I explained, she's had a lot of experiences in her life, but when it comes to the emotional attachments, she clearly has a very low emotional level in terms of being able to deal with deviating from normal patterns.
And further, at the bottom of page 23 of your report, paragraph 4, in the last sentence, you make the conclusion that in Ms. Manqele's case, it is without doubt that she displays remorse.
That's correct. I think she displays remorse as well as guilt. And simply, if you go back to my definition of remorse, remorse looks at the amount of insight that an offender has in terms of their action within the crime that was committed. And Ms. Manqele definitely shows very high level of insight into her action. And then taking it further from that, obviously in some of her statements, it was very, very clear that she had guilt as well. But taken from her statements of the insight into it, that she had taken the victim away from their family. So she's very, very clear of the consequences of her actions from that night.
Yes, but there's a big difference between regret in the sense that I feel sorry that somebody died, but I don't take responsibility for causing the death, and remorse that you're still feeling sorry that somebody died, but at the same time you're taking responsibility that your actions caused that death. Did she show any signs that she is taking responsibility that the action caused the death of the deceased?
Absolutely. I think, and also if you go back into my definition of what remorse is, in terms of the effect that it then has on that person's life, I'm aware that Ms. Manqele, out of her own free will, did contact a psychologist and started seeing a psychologist because of trying to deal with her emotions. If you also have a look in my report, I've also stated in terms of the post-traumatic adjustment phase, if somebody wasn't feeling remorse, there wouldn't be that sense of post-traumatic adjustment.
Thank you, Malik. I've got no further questions for the witness.
Dr. Haley, talking about remorse, the court has got its own parameters for determining whether a particular accused is remorseful or not. And the court every day deal with that kind of thing, and they've got legal parameters for measuring that. The famous case is that of Machichi, wherein Judge Conan, a colleague of mine, expressed himself on the essential difference between remorse and regret. And many an accused person is just regretful and not remorseful. When we speak of remorse, we're talking of something higher than regret. And so it is for the court to decide whether she was indeed remorseful or not. People who are remorseful after committing crimes, you can tell from their behavior. Some cooperate with the police And we find that every bloody day in courts of law here. And others dash off and they run away from the law. And when they are caught after a number of weeks, then they say, I'm sorry. And just simply to say sorry is not good enough. And it's for the court to decide whether one is remorseful or not. I know you might have ideas, criminological ideas on remorse and regret, but I'm merely pointing out that the court also has its own measuring stick for that type of thing, okay?
Yes, my lord.
Right, any examination?
Just one aspect regarding the point for which the Honorable Court has just pontificated to the witness and see if I can get anything from it. There is evidence before court that immediately the deceased was pronounced to be no more. The immediate and next action of the accused was to attempt to take a life, other than the other initial attempts to try and resuscitate the deceased, having realized that the things had gone awry. What would you attribute that to, if you can, in terms of regret, remorse, and guilt, if you can? I'm merely inviting you because you are an expert, and I have a suspicion that you might be helpful to your court.
Sure. Look, obviously I can't do a psychological diagnosis of what she experienced at that time, but I think it is really important to understand that immediately following an extreme stressful situation, it's a liken to somebody who goes and eats 20 bars of candy and has that drop after that initial sugar rush. And I think, the realization, and particularly in a lot of circumstances where people commit actions or commit crimes that they never intended to commit, or things go horribly wrong, and that's that dawning of what has actually happened in the situation. A lot of times people start becoming self-inflictual. And I think we've seen that in many, many cases where a lot of people, even though the courts may have found that they were not remorseful, who have afterwards taken their own lives. I think it's a factor that hasn't been well enough researched. But obviously I couldn't speak to my lord about what his definition of remorse would be.
And my instructions are also that but for the bail condition, it has always been the desire of the accused first to deal especially with the mother and the daughter of the deceased and speak to them heart to heart in order to share the grief that she feels for her loss and their loss. And if that is brought to your attention, also on the same scale of remorse, guilt, and regret, what would your comment be?
I did speak to Ms. Manqele about going through a process of restorative justice. And I think for her, it's very difficult not having her elders, losing her father during the time she initially wanted to do a restorative justice process with the family. Her father wasn't very well, and it became very difficult. And when he passed, it became even more difficult for her because she, in her words, said that she didn't have now elders to approach that she could go to. But it is something that she has thought about and something that we did speak about.
I'm going to excuse Mr. Lee. Mr. Lee, thank you. You may stand up.
At this stage. After we spoke this morning with my lordship, the state has decided to call one witness in respect of sentencing one of the brother of the deceased, and therefore I beg leave, my lord, if that is possible, that we can call that witness now and maybe finalize this evidence.
Is he here?
He is present indeed, my lord.
And he's ready, willing, and able to come and testify.
I trust so, my lord.
Sit down.
Would you like to an interpreter or English?
No, English is fine.
Please state your full names on the record, please.
Teboho Habedi.
Do you have any objection in taking the oath?
Nope.
Do you swear that the evidence you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Raise your right hand, says God with God.
So help me God.
Thank you, my lord. Mr. Habedi, is it correct that you are the younger blood brother to the deceased?
Yes, that's correct. Can I sit down?
And is it correct, yeah, my lord, I request that the witness maybe sit down while he gives evidence in court.
You have given evidence before.
Yes, I am.
It's not the first time.
No, it's not.
Yeah. So do you mind giving it while you're standing?
Okay.
Right.
So I'll stand.
As pleases my lord. Mr. Habedi, is it correct that you are the spokesperson for the family in regard to this?
Yes, I am.
Can you very shortly describe the setup of your family in respect of your communal mother?
Excuse me, say that again?
Can you just explain the setup of your family in respect of your communal mother?
The setup of my family. Are you asking how is my family doing?
Yes. You say you're the blood brother to the deceased.
Yes, I am.
Okay. And was he the first brother or the last brother? Can you just explain
Oh,
how many
oh,
brothers,
that's-
how many sisters you have?
He's the firstborn. Then we had another brother who passed away. His name is Nari Habedi. Then I'm the last born. And my name is Teboho Habedi.
Just speak
3
loudly.
brothers.
You are the last born of the boys.
Iyapa.
And do you have any other close cousins or whatever who is regarded as family of the deceased as well?
Yes, I do. Which is
Please explain to the court.
Mpo and Luyanda and Nari. Another Nari.
Are these your siblings? Are they your sisters?
They're my cousins, cousin brothers.
Cousin brothers.
Yes, sir.
Cousin brothers.
Cousin brothers.
Now, it's correct that at the time of the demise of the deceased, all of you were staying with the deceased in
Yes.
one house.
Yes. Well, there's actually 2 houses in the same yard. So, yeah.
And can you explain to court what the effect of the demise of the deceased had on yourself personally?
Personally, myself, Nkululeko was my bigger brother, and we spent a lot of time together. Now I don't have anyone to look up to, because usually when they beat me up, I call him. Back in those days, the family is trying to be strong. Mom's is acting strong, but I know that now it's killing her. But as a family, we're getting there.
And what has been the effect on your mother?
Hey, my mother. My mom is not taking this well. She looks strong, yes. She's not taking this well, and every time when she cries, I'm there. I have to look at her every time when she cries. Ash. She's not taking anything okay.
And did the deceased have any children?
Yes, Lesego and Tsogofatu.
Sorry to say again?
Lesego, that's the older sister, and Tsogofatu. That's the last born.
And how old is Nseko?
She's 14.
And are you in a position to say what effect this incident had on her?
She was crying today. She was crying yesterday. She's not taking everything well.
And where is Nseko currently staying?
She's staying with her mom.
In respect of the unity in your family, what was the effect of the deceased's demise on that?
Well, Nkululeko was the type of person who could bring all the family members together, including the distant cousin and all the stuff. I'm worried now. Since he's gone, I'm worried. What's going to happen? You want me to say that again? You want me to say that again? Nkululeko was the type of person who would bring all the family members together, including the distant cousins. Everybody loved him. Now that he's gone, I am worried whether we are going to be as close as we used to be.
He was a unifying force in the
Yes, Yapa.
And the deceased son, how old is he at present?
He's 3. He's outside.
Sorry, how old? I didn't.
He's 3 years old and he's outside
And where is he currently staying?
with the mom. Brett.
Thank you, my lord. I've got no further questions.
If you were to describe the effect of the death of Nkululeko, the deceased, to the court, if you were to describe it and how it affected the family,
He was the.
you say it affected the family. Let's switch it off.
Off.
Right. How did his death affect the family?
Nkululeko was the breadwinner of the family. He was the head of the family. Now I have to be in his shoes, and which is very hard.
So he was a breadwinner, you say.
Yep.
So how has his death affected the family? I mean, if it's not you to replace, to become a breadwinner, then the family is not affected.
The family is affected, pa.
In what way is the family affected?
Especially my mom. The other family members, they're not that affected, even though he put the family together. The most affected guy is my mom. My mom is not taking this well on a daily basis. She's not. Now that my uncle also passed away a couple of weeks ago, things have become worse. It's killing us, pa. We used to have a brotherhood. We used to live together, like with Nkululeko. Every single day, we used to be together as brothers, including Momtsir and Luyanda. We're not taking this well. You might see us smiling because this family is a jolly family, anyways. But we're not taking it well. If the cause of this was different, most probably will heal. It's going to take time, but I'm not sure that we will.
Please switch off your cell phones.
It happened so fast, pa. We weren't expecting this.
Yeah.
Just one aspect to clarify, assist the court in understanding or trying to at least go along with your loss, which is admitted.
This is.
First of all, my instructions are that the accused has always wanted to communicate with the family regarding the incident to the extent that she could and make everybody understand, except that she had been restrained by her bail conditions that restricted her, especially talking to the deceased daughter and your mother. Are you aware of that?
Whether the accused wanted to come through.
Yeah, she was only stopped by the bail conditions. Because she was a suspect on the murder charge, she was told that you never speak to potential witnesses or anybody. Otherwise, she tells us, the defense team, that she has always wanted to sit down and speak, especially to her mom, the deceased daughter. Are you aware of that?
Not that I know of.
And the accused and the deceased daughter were very close, not so.
The accused and who?
And the daughter.
The daughter, yeah. They
Very
were,
close.
they were very close, yeah.
And they loved each other.
Yes, they did.
Including your mom also.
Yeah. My mom loved her.
And my instructions are also to state that having lost the deceased and shortly after she lost her father, she actually needed your mother more because there was something more closer than what could her mother be, because she had lost a biological mother. She couldn't get an aunt, but they were so close with your mother. Are you aware of that?
Am I aware of the fact that they were close?
Yeah.
Or am I aware of the fact that she knew my mom?
That they were close with
Yes.
your mom. Yes.
I'm aware of that.
And there would be some good reason to at least want some solace or at least sharing their experiences with your mom.
You want me to comment on that?
If you can, you don't have to.
Okay. Right. If you say I don't have to, then
And how old are you, sir?
I'm 28.
Are you employed?
No.
Fine. And the other family members that were staying in the house, how old are they?
26, 24.
They are adults.
Yeah, young adults.
Okay. And the only minor that we are talking of is the daughter of the deceased and the other child of 3 years old, not so.
Yeah.
As for the rest of yourselves, are adults that can actually fend for themselves, not so.
I can what?
Go and fend for themselves.
Yeah.
You did not have to depend on the deceased.
By that time.
I mean now.
I talk about now.
Yeah, you can grow up about.
Yeah, we can grow up. We can go out and under.
And is it correct that even at the time of the incident, before it happened, your mom, Mrs. Habedi, was staying in Soweto, not in Alexandria with all of you. Is that correct?
She was staying in Soweto.
Yes.
Yes, she was.
No further questions.
You say you have taken over as a breadwinner and yet you are unemployed. How do
Yes,
you
I'm
manage?
unemployed. But I've got a van that I work with. That I do a bit of tenders there and there, you know. My little brother used to work, he doesn't work anymore. My other little brother, Luyanda.
Your boss was you.
Yeah, thank you, pa. Ito ke tsampa. Ke leboga pa. Thank you pa. Ke leboga pa.
Yeah, I've got no further questions.
I don't get to ask questions. Oh. Come ask.
Argument in mitigation and aggravation, and that can only take place tomorrow morning, after which I will be able to give the sentence. More.
Indeed, my lord, I'm available.
I will be ready to address the question. Nothing is lodged.
Argument in aggravation and in mitigation tomorrow morning. Kenneth. Say. We are going to go into another stage of the trial, that is where a stage in which lawyers will be arguing among themselves. And that will only take place tomorrow morning, after which the court will pronounce that sentence. Yeah. You are still out in bail, isn't it? Right. The court is going to adjourn until tomorrow morning.
All rise.
Wow. So we feel that it's our You laughed and I'm like, oh my God, sorry. Sorry.
Sorry.
J191. 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 Ya, apa se para con Okay,